Hi, and welcome to How to Prepare for the End of the Eviction Moratorium, Rental Assistance, Legal Aid, Mediation, and Payment Plans. The Solid Ground Tenant Services Program is pleased to present this critical information to renters in the Seattle and surrounding areas of King County. This information will help you to access available supports and services while advocating for yourself in Eviction Resolution Program mediations. Thank you for allowing us to share this PowerPoint with you. The Tenant Services Hotline is available Monday, Tuesday, and Thursdays from 10:30 a.m. to 1:30 p.m. The phone number to the hotline is area code 206-694-6767. And thank you for filling out and returning your surveys. That information is so important to us and critical to us improving our webinars. Thank you so much for sending in surveys. So today's presenters include the Solid Ground Tenant Services team. That will be Celestine Berry-Smith, myself, and I am the Supportive Services Manager. Olivia Mansker-Stoker, Tenant Counselor. Edgar Aldrett, Bilingual Tenant Counselor. And working along with us is Will Tosburn, our Government Affairs and Contracts Coordinator. Also presenting today from Dispute Resolution Center of King County is Marilyn Littlejohn, the Community Engagement Specialist. Also partnering with us, I'd like to acknowledge from the Tenant Law Center, Michelle Lucas, who is the Directing Attorney.
Thank you for attending today's presentation. In this slide, we have the agenda for what we'll be speaking in today's presentation. First off, we will start with who is this presentation for, followed by how have protection and programs for tenants changed. Then what steps should you take if you are at risk of eviction? And followed by what does an eviction resolution notice look like? So we will have an example of that for you to look at, followed by information about staying in your home and also applying for rental assistance, as well as access to free legal services. Olivia Mansker-Stoker will then take over the presentation and provide you information on mediation and payment plans as well. Followed by Marilyn Littlejohn from the King County Dispute Resolution Center. She'll be providing her presentation as well. We will be having a Q&A discussion in a separate webinar. All right, who is this presentation for? The COVID pandemic has resulted in a loss of employment and income for many King County residents. Many tenants are struggling to keep up with rent payments and have accumulated significant rental debt. So this presentation is for you if you are a resident of King County and you are behind on rent and or you believe you are at risk of eviction when the moratorium lifts, and or you have received an eviction resolution program notice from your landlord. So how have protections and support for tenants changed? Well, by looking at the slide, we can see the two columns, one with before and during the eviction moratorium, and then the one on the right after eviction moratorium. So currently the moratorium is set to expire at the end of day of June 30th. Now looking at the rental assistance row, what happened during and before the moratorium? Well, funds were available, access through the home base and United Way King County website. Now, with the recent legislation that's occurred with the federal government and the added funding that was recently passed this early year, you can see that there was more funds available. So the funds are currently being accessed through the EPRAT program by the King County. As you can see there on the right column, so after the moratorium, there will be more funding available. So currently there is more funding, but it also will be available after the moratorium as well. So the right to counsel on the second row there, you can see there. So before and during the moratorium, it was non-existent. And currently with the recent legislation that's occurred and that has become law, that the right to counsel will be available to certain tenants, and it'll be free legal counsel to certain tenants in Washington state. Now, more information regarding the right to counsel and general questions will be answered on our separate Q&A presentation done by the Tenant Law Center, and a link will be provided. Mediation and payment plans. Currently and before the moratorium, mediation is voluntary for both tenant and landlords. However, post-moratorium, before tenants can be evicted by a landlord, that the landlord must require to offer mediation and enter into mediation if the tenant is interested. Now, in regards to protections against evictions, a lot has definitely changed during the moratorium, and especially during the pandemic, and a lot of tenants did suffer. So legislation has gone into effect, especially in the city of Seattle. There has been more recent protections put in place for tenants. And if you have questions about tenant protections in your area, you can send us an email at tenantlaw@solid-ground.org. What can you do if you are behind in rent and or at risk of eviction? We have 4 points here. Then the first one is stay in your home. So you cannot be evicted before June 30th, 2021 under the evictions moratorium that's in place. If your landlord is harassing you, recommend that you seek legal counsel, reaching out to free legal assistance or a resource that can provide you contact with an attorney. After June 30th, 2021, landlords are required to inform tenants of assistance available through the Eviction Resolution Program before filing for eviction. Now, applying for rental assistance. It is recommended that you apply as soon as possible in order to get in early. We understand that the EPRAP program and home-based King County has already opened up and tenants have been applying. So at this point, it is recommended that you still continue to apply and seek out other resources for which we will provide information here. Accessing free legal services. Reach out to an attorney for legal advice if you get a notice for the Eviction Resolution Program or are being harassed by your landlord, or if there's an eviction that is filed against you, which is the unlawful detainer. Mediation and agree to a payment plan with your landlord. Mediation is through the Dispute Resolution Center. The goal of mediation is to create a reasonable repayment plan in order to avoid an eviction. Consult an attorney before mediation and before signing a payment plan. What does an eviction resolution program notice look like? We have a copy of the page 1 and page 2 of this eviction resolution notice. As you can see there on the top right, it is stated as a voluntary notice at this point. However, once the moratorium is lifted, that will change and it will no longer state voluntary notice. And as you can see on page 2, there are some information that shows of where to seek rental assistance in your county, and the Dispute Resolution Center information as well in your county, as well as the Housing Justice Project information to seek out in your county. On this next slide, you can see detailed information of the page 1. One thing I would like to point out is the respond date on the top. 14 days after this notice given to the tenant. This is something to be aware of, is that it will be 14 days for the tenant to actually respond to this notice. Stay in your home. The eviction moratorium is set to expire at the end of day, June 30th, 2021. Before then, your landlord cannot evict you for non-payment of rent, give you a rent increase notice, add late fees to your ledger, or send your debts to collections. This is all covered again under the evictions moratorium. After Your landlord cannot evict you for unpaid rent without giving you the opportunity to go to mediation and offering and/or agreeing to a reasonable repayment plan. Again, this is all part of the new legislation that has recently passed entitled the ERP. And that is made up of three components for which we will speak of momentarily. Report violations to the Attorney General's office. So if your landlord is harassing you or attempting to violate the evictions moratorium, it is highly suggested that you reach out to the Attorney General's office, who is currently enforcing the evictions moratorium. One way to file a complaint with the Attorney General's office is to fill out the complaint form on their website. It can be searched by going online and doing a Google search for the COVID eviction moratorium complaint form, or we can provide you the link after this presentation. You could also leave a message on their voicemail system at 833-660-4877. You could also reach out to a legal aid provider, for which we will provide you some information here on our slide 12. If a landlord willfully violates the order, they could be charged with a gross misdemeanor. Limited exceptions to the eviction moratorium. There are few limited exceptions to the eviction moratorium where a landlord will ask a tenant to vacate the dwelling. One is safety issues. Landlords can order a tenant to vacate if the tenant poses a significant and immediate risk to the health, safety, or property of others. And the landlord must attach an affidavit attesting to this fact. This instance would apply to all types of tenancies and all types of lease as well, whatever the tenant might be under at this point. And the landlord must attest again to the tenant being a significant immediate risk in an affidavit form that has again to be in particular, and this is how it's stated in the evictions moratorium. Now, for month-to-month agreements, landlords can terminate month-to-month rentals with a 60-day notice, but only if the landlord intends to personally occupy the premises as their primary residence or to sell the property. Now, that 60-day notice that's issued by the landlord needs to be issued in an affidavit form signed with the language under penalty of perjury and also served under Washington laws. Now we're going to talk about rental assistance. So if you're behind on rent, there are two ways to find rental assistance, and try both. You can decline the assistance if you're able to pay in full on your own. But again, do not fail to apply if you're unsure of your situation. EPRAP, which is the Eviction Prevention and Rental Assistance Program, is a program that's handled by the King County, and it's available through their website and can be found by Googling King County EPRAP, is currently handling all the funding that's coming from the federal government and disseminating to the county. So this would be one location where you can actually go and participate in the lottery program that is currently happening. Also with the United Way of King County, which is linked back to the EPRAP program and to the portal for tenants to actually go and register. So the EPRAP funds can pay for past, present, and future rent in some cases. And also the application has already been open since May 17th, 2021, and is currently open at this point. Another source for rental assistance is 211. You can call 211 by dialing 211 on your phone and let the operator know you are seeking rental assistance. They may be able to connect you with the providers who are offering rental assistance outside of the EPRAP program. Okay, accessing legal services. So if you are served an eviction notice, an eviction resolution program notice, or believe your landlord is infringing on your rights, reach out to the following legal aid providers, starting with the Housing Justice Project. In the Housing Justice Project, you can be reached at 206-267-7069 to leave a message with the staff, or you can contact them via email at hjpstaff at kcba.org. Again, that's hjpstaf@kcba.org. And also, there's the East Side Legal Assistance Program that represents the east side of King County, the Northeast, and the Southeast region as well. It can be reached at 425-747-7274. And they have a Spanish intake line as well for the Spanish-speaking tenants at 425-620-2778. And if you are in a situation involving domestic violence, they can also help you out no matter what part of the county that you're located in. Next, we have the Tenant Law Center. You can contact them at 206-324-6890 to leave a message with their staff, or you can contact us here at Solid Ground, our tenant services hotline, and we can provide you a referral to them for a free 10-minute consultation with an attorney. Also, you have the Northwest Justice Project that represents the entire state of Washington, and they can be reached at 211, and you can ask for legal aid for housing to be directed to the proper organization. Accessing legal services, it's more than just mediation. Consult an attorney for legal advice prior to engaging in mediation to find out to see if an attorney can help you assess the legal pros and cons of engaging in mediation or taking a different path. For instance, an attorney can help you learn about the option to pursue the matter in court and what it would look like. For example, how much time would be expected of a tenant um, instead of going through mediation. So there is that option for tenants that feel that they would think that they might not need to go to mediation. But again, it would be best to speak with the attorney to see if they can find out based on your particular situation to see if it would work for you. Again, it's all dependent on your individual circumstances. And another reason for engaging with an attorney is before you sign any agreement, a tenant should have an attorney review it, whether or not the agreement is a payment plan agreed to in mediation or independently offered by the landlord. This is something we always highly suggest that a tenant do before signing any type of legal document, that you have it vetted by an attorney to see if any violations are occurring in there or your rights are being violated at that point. And this can also, again, with mediation, you want to make sure that before that you engage, if it'll work for your personal particular circumstances. All right, now at this point, I would like to pass it off to my colleague here, Olivia Mansker-Stoker, who will continue with the presentation.
Thank you so much, Edgar. I'll continue now and talk a little bit about mediation. So, like Edgar mentioned before, the goal of the Eviction Resolution Program is to reduce the number of evictions filed in court due to non-payment of rent. And mediation is a critical piece of that process because it gives tenants the opportunity to sit down with their landlord and try to resolve the issue outside of court. The Eviction Resolution Program is a broader umbrella that includes referrals to rent assistance, legal services, and an opportunity to participate in this mediation program through your county's Dispute Resolution Center. And mediation brings landlords and tenants together in that facilitated conversation with the goal of creating a payment plan agreement to avoid eviction. So if a landlord intends on evicting a tenant for non-payment of rent after the moratorium is over, that landlord must inform a tenant of their right to participate in the ERP and therefore to participate in mediation. As a tenant, you must reach out to your county's Dispute Resolution Center in order to participate in the ERP, and you will have the chance to respond to your landlord's notice of the Eviction Resolution Program that Edgar showed you. You will have a chance to respond to that after being served to it in order to set up a mediation appointment. Your county's Dispute Resolution Center may also reach out to you if your landlord has served you with this notice, as the Dispute Resolution Center will also receive a copy of this notice from your landlord. So then, if you, as a tenant, decide to participate in ERP mediation, your landlord must also participate in mediation. A legal provider like the Housing Justice Project can also connect you to the ERP. So how does this whole thing work? We have a timeline here that starts when the landlord serves you a notice of the Eviction Resolution Program. And again, this is the notice that Edgar showed you the first and second page of earlier. If you receive this notice before the moratorium ends, the landlord cannot also serve you a notice to pay or vacate. So no landlords can serve any notices to pay or vacate until at least June 30th of 2021, this year. If it is after the moratorium ends, then the landlord may also be able to serve you a notice to pay or vacate, but they must serve you the notice of the Eviction Resolution Program as well and give you the opportunity to go into mediation first before anything goes into court. So your first step, if this happens, is to contact an attorney. A legal aid provider will be able to help you throughout the entire process. And once you receive this paperwork, it does become a legal situation where you want to get their advice. They'll be able to talk to you about your specific situation, where you stand when it comes to your finances, and what clauses you might want to advocate for in a payment plan agreement with your landlord. And you can take this knowledge with you into mediation if you get the chance to speak to an attorney beforehand. We also really recommend speaking to an attorney before you sign any payment plan agreements, because they'll be able to give you some advice on whether or not it looks like a good agreement for you to sign given your circumstances. Your next step is to decide if you want to participate in the Eviction Resolution Program. If it is before the moratorium ends and you receive an ERP notice, you do not have to participate in order to prevent something from going to court, because the landlord can't give you a notice to pay or vacate. However, if it is after the eviction moratorium ends, you will have 14 days to respond to that first notice that you get from your landlord to participate in the Eviction Resolution Program. If you do decide to participate, then you can follow the instructions on the notice to schedule mediation. And you can contact the Dispute Resolution Center directly via email, voicemail, or by completing the intake form on the DRC website. The form is listed here, www.kcdrc.org/schedule-an-appointment. If you do go to mediation, that facilitated conversation is free for landlords and tenants to participate in. So what is the mediator's role? Mediators are neutral third parties, and they will not advocate for you or for the landlord. They cannot suggest methods of self-advocacy to you or the landlord. They are there to ask questions of both sides. They're there to facilitate the conversation between you and your landlord and make sure that it goes as smoothly as possible. Mediation is completely confidential. So anything that you say in mediation, anything that your landlord says in mediation, that's confidential. And the mediator cannot make any statements to anybody outside of mediation regarding the session. If no agreement is reached between you and your landlord in that session, the Dispute Resolution Center, not the mediator, will issue a certificate to both the landlord and the tenant, verifying the date and the names of people who participated in the mediation. So who else will be in the room? All parties must be present for an agreement to be made. So on the landlord side, the homeowner or a property manager representing the homeowner who acts as landlord, one of them will be there representing the landlord side. And then representing the tenant side would be you and anybody else who is on a lease with you. So any other adult whose name is on that contract as a tenant should be in the room. If you have roommates who are not able to attend, then you may create a proposal to bring to the other roommates later. However, the agreement is not valid unless all parties sign indicating that they accept the settlement terms and conditions. Now, landlords are likely to have an attorney with them in the session, and you can bring an attorney with you as well. There's likely going to be a lot of demand for a tenant attorney through local programs. However, even if you're not able to get an attorney to attend with you, we recommend getting their advice on how to represent yourself, on how to navigate your situation, and how to move forward. Now, if you or your landlord has an attorney with you, the attorney will not be representing you in that they will not be speaking for you in mediation. You would be able to consult with them on the side. And the same goes if you bring in a friend, a family member, or another advocate. You can bring in anybody you like to provide support for you on the side during mediation, and you can consult with them in a separate room. However, they cannot participate in mediation or represent you. So your friend you may have for emotional support cannot speak to the mediator or the landlord, but you could step aside from mediation and talk to them if you want to talk through your thoughts or get their opinion or just get emotional support. So what will happen in mediation? Again, it is a facilitated conversation to come to a reasonable payment plan between you and your landlord for unpaid rent accrued from March 1st of last year, 2020. In this session, you will discuss the amount of monthly payments, the number of monthly payments, and you can negotiate on other terms of your lease or living situation as part of the process of getting to an agreeable payment plan. And like I mentioned on the last slide, you can go to a private room and consult with an attorney or another advocate during mediation. We have room in quotation marks here because it's going to be a virtual meeting. So like on Zoom or something like that. So in your separate room, you can ask an attorney for advice about whether the proposed payment plan is reasonable based on your individual circumstances and whether you're likely to prevail if your attorney presents your case in court. Now, no worries. If you don't have an attorney with you, that's fine. You do not have to come to an agreement and sign an agreement at the end of the mediation session. And the mediators will likely encourage you to consider the final proposal before signing it. So even after the eviction moratorium ends, you are not required to reach an agreement on the payment plan and mediation. You could even choose instead to ask your attorney to argue your case in court and turn the decision over to the judge to decide what's reasonable. So what is a reasonable repayment plan? I'll start by looking at the period of time you would be creating a payment plan for. You can create a payment plan for back rent accrued between March 1st, 2020, and up to 6 months following the end of the moratorium or the end of the public health emergency. The landlord cannot require a tenant to commit to payments that exceed a third of your monthly rent. You can offer to make payments over a third of your monthly rent if your finances allow, but you are not required to do so. So, for example, if your rent is $1,000 a month, your landlord cannot require that payment plan payments be more than $333 a month. So that would total $1,333 a month payments for as long as the payment plan lasts. There is no minimum amount per month that the law requires. So there's no smallest amount that you can propose. You can propose payment plans to be at any amount of money per month. Doesn't mean that the landlord will accept that agreement, but you can still propose it. Also, the due date for your rent and for your payment plan payments can be different days of the month. So if you pay your rent on the 1st, you don't have to pay your payment plan payment on the 1st. You can pay it on the 15th if that works better for your finances. You can pay it whenever works for you. Now, payment plans cannot begin sooner than 30 days after the plan is offered. So you have a little bit of a buffer period between signing the agreement and the agreement coming into effect. And I do want to quickly clarify that when I say that the payment plan payments could be on any day that works for you, I mean that the agreement can require that payment plan payments be due on whatever date you pick. It does have to be it is a consistent due date that you would then commit to when you sign the agreement. Now, the payments can only cover rent and not legal fees, late fees, or other charges. And if you remember from earlier when Edgar was talking about late fees, it is illegal for a landlord to charge late fees for the period of time between February 29th, 2020 and June 30th, 2021. After the moratorium expires, the landlord cannot charge accrued late fees for this period of time. Now, payments can come from any source of income, including benefits, assistance, or subsidy programs, or from pledges by nonprofits, churches, religious institutions, or governmental entities. There are a few things that cannot be in the payment plan agreement. There are illegal clauses which cannot be enforced if they are in a payment plan agreement. So the agreement cannot require you to apply for government benefits. A landlord cannot evict you without giving you proper notice under the law. So this means that you cannot waive your right to receive a proper pre-eviction notice from your landlord if your landlord is planning on taking something to court. Additionally, the landlord cannot require you to agree ahead of time to pay attorney's fees, court costs, or other costs related to litigation if the issue did go to court. The only person with the authority to tell you that you owe attorney's fees or court costs to another party is a judge. Finally, a landlord cannot cancel your payment plan because you're not in compliance with the rental agreement. If your landlord claims that there's some issue that you're not complying with your lease, like they say that you're smoking in your unit when you shouldn't be, that is a separate issue from the payment plan issue. And if a tenant defaults on a payment plan, the landlord can either apply for funds through the Landlord Mitigation Program or move forward with an eviction. The landlord cannot choose to do both at the same time. So here is how you contact the King County Dispute Resolution Center. They hold weekly information sessions for tenants about the Eviction Resolution Program on Tuesday at noon over Zoom. And there are also recordings of the presentation that are available in English and Spanish on their Facebook page. The link is here. Email is the best way to contact the Dispute Resolution Center, and their email address is housing@kcdrc.org. You can also contact them by phone. Their phone number is 206-443-9603. The extension for Spanish is 103, and the extension for English is 111. And finally, if you live in Bellevue or Kirkland, you should contact the City of Bellevue Conflict Resolution Center. Their phone number is 425-452-5288. Their email address is bcrc@bellevuewa.gov. That is BELLEVUEWA.gov. And we have a link to their website on this slide as well. Now, there are some accommodations if you need accommodations to access mediation. First, if you have no access to a computer, then you can phone in by calling a 253 area code number to the King County Dispute Resolution Center. So if they're having an online meeting, You don't have to participate it through a computer. You can participate over the phone. 2, if you need language translation, the Dispute Resolution Center of King County utilizes a service called Boost Lingo that gives them on-demand access to interpreters through Zoom and through phone lines. And finally, if you have need of other accommodations, then the Dispute Resolution Center of King County works individually with each client to ensure access to services. Now, after the eviction moratorium expires, there will still be protections for tenants, like we've been talking about throughout this presentation. However, these protections will not necessarily prevent landlords from filing evictions in court. It provides protections for tenants by requiring the landlord to engage with you outside of court first. And there are some other protections which may apply to your situation on a case by case basis, depending on your circumstances. And so, for that reason, an attorney would be able to help you navigate this. I'll go over a quick summary of the mediation and payment plan slides now. Eviction Resolution Program offers free mediation as one of its key services, and a goal of mediation is to enter into a payment plan for unpaid rent from March 1st, 2020. The process will most likely begin by a landlord serving a notice to the tenant, inviting them to participate in the Eviction Resolution Program, and emailing a copy to both the Housing Justice Project and the Dispute Resolution Center. So that is something that your landlord would do. 4, tenants are strongly encouraged to consult with an attorney as soon as possible, before mediation and before signing a payment plan. The mediator's role is to be an impartial facilitator, not an advocate for either party, but to facilitate the conversation between both parties. And finally, the King County Dispute Resolution Center will have more information on how to prepare and what to expect in an ERP mediation. And we are so lucky to have Marilyn Littlejohn with us today from the King County Dispute Resolution Center. In her presentation, she talks all about the mediation process and what their services can provide. Thank you very much for attending this Rent Smart workshop. You can contact our hotline on Mondays, Tuesdays, and Thursdays from 10:30 a.m. to 1:30 p.m. We speak to tenants throughout Washington State, not just in King County, and our number is 206-694-6767. We have information for tenants who speak all languages. You can also reach us at tenantwa@solid-ground.org. That is TENANTWA at solid-ground.org. Thank you very much.
Hello, everyone. My name is Marilyn Littlejohn, and I am the community relations or community engagement specialist, as well as one of the mediators at the Dispute Resolution Center, King County. Just a word about the Dispute Resolution King County. It's a community-based organization that's been around for 35 years. And we specialize in helping individuals, organizations, and communities resolve conflict. And our goal is always to, as neutral parties, work with all the parties involved to come up with a solution that each party finds workable. We do this using listening skills and other techniques, and we do this so that by the time they have an agreement, they're comfortable with their agreement. That said, we also encourage the participants to talk to whomever they need to talk to, attorneys or supervisors or spouses, about the agreement so that they are assured that this is what they want to do. So I want to talk to you about mediating settlement agreements to pay back rent owed. My colleagues from Solid Ground have shared with you that landlords cannot evict tenants unless they give tenants an opportunity to engage in mediation. And they do this after the moratorium by issuing a notice, an Eviction Resolution Program notice. That is not an eviction notice. It is a notification that there are services available, and it includes information about how to reach out to these services. Landlords are required to send that notice that they give to you to the DRC and to the Housing Justice Project. When we at the DRC receive that notice, we will reach out to you and begin the process of explaining mediation, how we may or may not be able to help you, and scheduling a mediation with you and your landlord should you both want to pursue this. However, I will also add, if you want to pursue a mediation, your landlord must pursue a mediation. So the key questions for today are, what is a mediation? What can a payment plan settlement cover? And how to prepare for a mediation on payment plans. And so to give you an idea about what a mediation is, I want to share with you a short video that in a cute way explains it.
Mediators facilitate dispute resolution processes, yet options and solutions are driven by the participants. A mediator won't tell either person what to do. Instead, they'll ask questions that help you create solutions for your situation. They will always be impartial and supportive. Dispute resolution services are confidential and impartial. If you reach a resolution during your mediation, that written agreement can be used in court, yet what is said to achieve that resolution is private. Remember when entering mediation that you don't have to reach a resolution and you don't have to stay. The whole point of mediation is to make progress and have a conversation that actually gets somewhere. The mediator will ask detailed questions and carefully observe everyone participating to try to make sure all the issues are addressed. Washington's local dispute resolution centers offer several processes. Some of these include coaching, helping you form the conversation with the other person so you can speak to be heard and listen with understanding. Conciliation, carrying offers of resolution between the two people in conflict in a series of separate phone calls to help negotiate a solution. Facilitation, supporting communication among a group of people to help them plan or address issues or conflict. And mediation, a joint session, online or in person, held with or without lawyers. The mediator will coordinate the process while you create, offer, and negotiate your own solutions with the other person involved in a supportive atmosphere. Dispute resolution centers also provide training and mentorship to help people build skills to resolve future conflicts in their family, workplace, and community. Conflict is natural. It's part of the human experience. Our perceptions about conflict are shaped at an early age by our life experiences. Participating in dispute resolution helps everyone learn effective communication. Mediators care about your situation. Mediators support you in figuring out how to move forward and how to succeed in the future. Mediators help you explore your best options and expand solutions to help you move forward. Imagine an experience where you are in a difficult situation, yet you're provided support at each stage of the way. A dispute resolution center's goal is to help you feel heard, safe, comfortable, supported, and cared for as you develop solutions. Your thoughts and ideas are important.
Okay, so that was a lot of information. So I want to just take a few moments to highlight a few key things. What is a mediation? It is a meeting. It is a conversation between individuals who have a disagreement or conflict. It is voluntary, at least for the tenant. If the tenant wants to participate, the landlord must participate, but the tenant can choose not to participate. If the mediation goes forward, it is a confidential and privileged conversation, which means that no one involved in that mediation, unless the parties agree to it, no one in that mediation can speak about the details, the offers made during that mediation. It's a privileged conversation, which means that no one, including the mediator, can be subpoenaed to go to court to talk about the details that occurred in that mediation. There are exceptions, however. A signed settlement agreement is a contract and may be shared in court. As mediators, we also must report to court whether a mediation has occurred, if a dispute has been settled, who the parties were that were involved, and the number of times the Dispute Resolution Center contacted the tenants. Other than those things, no details about the mediation and what was communicated in the mediation can be shared outside the room in which the mediation occurred. Another really important thing is that the mediation is facilitated by neutral party, yes, but this neutral party is a professionally trained mediator who has years of experience mediating all kinds of disputes. And the way we do so is designed to keep the conversation civil and to move the parties toward an agreement that they both can live with. There's no guarantee that a resolution will be reached. In fact, it is not required. But if the parties want to reach a resolution and want to reach an agreement and can, it will occur. Now, the video also shows several forms of mediation. There's the traditional mediation, face-to-face negotiation between the parties, with the mediator facilitating the discussion and the issues, facilitating the brainstorming of possibilities, and how they want to write up their agreement. Once they write up their agreement, we encourage them to make sure that the parties that they need to consult with can see that agreement before they sign it. Once they sign it, it is a contract that's admissible in court. Short of a mediation, we have facilitated conversations. These are face-to-face, and a mediator is present with the parties, but the discussion that they have is very preliminary. No binding agreements are necessarily made. They're just exploring options and seeing if they can determine a pathway forward. Sometimes we do conciliations. These are negotiations, but they're not face-to-face. The landlord and the tenant speak separately with the mediator or case manager, who will take offers as well as counter offers back and forth between the tenant and the landlord until they get to a point where they can reach an agreement should they be able to do so. As with mediation, an agreement is not necessary. This process is also voluntary. So once the mediation starts, if anything troubles either the tenant or the landlord, either one of them can stop the process and leave. Last, we do conflict coaching. This happens when the parties want to do their own negotiation separate from a mediator or even an attorney. What we would do is work with either party who wants the coaching to help them identify the issues they want to bring up with the other party, the possible solutions, help them identify or anticipate what solutions the other party might make, what kind of counter offers they might make, what they need to do, how to speak and how to listen so that they come up with an agreement that they're happy with. We will do this for both the landlord and the tenant if either one asks us to. So I've talked about the mediation process as a whole. Next, I want to talk about what a payment plan settlement can cover, especially after the moratorium ends. There's the payment plan itself, but there's also the lease agreement and the monthly rent or anything else that needs to be talked about to stabilize the housing for the tenant and the landlord. In addition to these specific topics, the agreement must also be very clear and specific about who will do what, when, and how. So if a new lease is to be signed, when will it be signed? If a new lease needs to be delivered, when will it be delivered? I want to next show you a few examples of agreement plans. So here's the first one. Amy, the landlord, will include Maria, the tenant, in a rental application she is preparing. If Maria delivers her 2020 tax return to Amy in person at the leasing office on Friday, April 30th. Also on April 30th, Amy and Marie will meet to sign a new 6-month lease that will become effective May 1st. Amy, the landlord, has also agreed to reduce the monthly rent by $200. So it is now $1,300 a month, and it will become effective May 1st. Maria has agreed to make payments of $500 per month on or before the 15th of each month until her rent arrears of $14,602 is paid in full. She will make her first payment on or before May 15th. Amy and Marie, in this case, have agreed that they will meet to adjust the payment plan to begin the following month after the signing if circumstances change. And the circumstances in this case will include the landlord successfully gets rent assistance, or Maria's income changes, or her economic situation changes, and she needs to make an adjustment in what she can pay. So here's sample 2. Again, a new lease will begin as a 6-month lease, which is renewable by mutual consent of the landlord and tenant. The rent amount will become $1,500 monthly. All other expenses noted in the lease, like water, trash, pet fee, will remain the same as this current lease. Upon commencement of the new lease, Jim, the tenant, will begin a 12-month payment plan to eliminate the rental arrears owed, $6,000, at a rate of $500 a month. They too agree that this plan can be amended under certain circumstances related to the availability of rent assistance or tenant's financial situation changes. In addition, they agree on how they will communicate with each other moving forward. And they will communicate using these email addresses for the respective parties. So that's sample 2. Sample 3, Jane will pay John, the landlord, $1,900 in the month of March to pay down the current outstanding balance of her account, which is almost $4,000, to get it just above $2,000. This is her new rental arrears. Beginning in April, in addition to paying her regular monthly rent of $1,545 by the 5th of each month, Jane will make additional monthly payment of $355 a month by the 15th of each month to be applied to her arrears, her $2,039 arrears. John acknowledged that this series of 6 payments will settle in full the current outstanding balance on Jane's account. Within 48 hours of signing the settlement agreement, Jane or John will send a new lease to Jane. It's a 6-month lease with a rent of $1,545. John and Jane agree that this payment is a reasonable payment plan based on Jane's current financial circumstances. If those circumstances change, they agree that this plan may be renegotiated, ensuring that monthly payments are reasonable based on Jane's ability to pay at that time. If Jane is subsequently approved for rent assistance, which reduces her rent arrears, this payment plan can be adjusted as well. So I have 3 samples of payment plans or settlement plans. All address the payment plan, all address the lease, all address the rent, and other contingencies. So the last thing I want to cover is what you need to do to prepare for a mediation on a payment plan. And the bottom line is you have to know your budget before you go into the mediation. You need to know what you can spend on rent to pay down your rent arrears. By looking at your budget, by looking at the balance between income and expenses, necessities, and other things, you can walk in prepared to know what you can offer, what you can do. Now, we're all familiar with budgets. You know, on one hand, you have income, on the other hand, you have expenses. Depending on what you do for a living, your income could be a wage or self-employment, or maybe you're on Social Security, or you get public benefits. On the expense side, you know, there's housing, rent or mortgage and utilities, but there's food, insurance, healthcare, other things. So one of the things you consider when you think about your budget are the things that are most important to you. What's the most important? What are the most important expenses for you and your family? And you know that before the pandemic occurs. But the pandemic has occurred, and your income or source of income might have changed. You may still have a salary, but it could be reduced because your hours have been reduced. Or you may not have a salary. You may be on unemployment, or you may have some other public benefit. And if you're fortunate, you'll have some rental assistance. On the expense side, you still have rent, but now you have to pay back rent. And then you have all these other expenses. And the key to moving forward is to think about what is not only most important to you, but what you may need to live without for a few months, or whether or not you can find another job. So when you think about preparing for a settlement agreement involving the payment plan, think about your budget. Is your monthly income greater than your monthly expenses? How have you included all sources of income and all expenses? Have you considered unexpected costs or emergencies? Emergencies do happen. Have you considered or set aside some funding for emergencies? What expenses can you do without for a while? And that will vary with every family. One of the most important things you need to remember is the legal guidance about reasonableness. No landlord can ask you to pay more than 1/3 of your monthly rent. So if your rent is $1,500 a month, no landlord can ask you to pay more than $500 to cover rent arrears. Also, try to remember what can change in your life and what contingencies you might want to write into the settlement agreement. What if you are awarded rent assistance? What if your financial situation does change for better or worse? Will there be an opportunity to renegotiate that payment plan? So I've covered what is mediation, provided you some examples of what an agreement plan could look like, and talked to you a little bit about how to come prepared to talk about a payment plan. I want to close by just providing you some information about who to contact. You can contact the DRC at 206-443-9603. And we have a line for those who speak Spanish and a line for those who speak English. And we can also get other interpretation there. We also suggest that you do contact the Housing Justice Project for any legal issue that you want addressed. And then we have the contact information for rent assistance. At this point, I am concluding my presentation.